This is Block 10, the 60s, Part 5, an activist court, with the section the Warren Court and the Berger Court. These two Supreme Court justices, on the left Earl Warren and on the right Warren Berger, were both Republican appointees, Earl Warren by Eisenhower and Warren Berger by Richard Nixon, nominated by relatively moderate conservative presidents, but as it turned out that on the bench that these two men were anything but conservative. They were, in fact, very, very progressive, and both of them served to increase the role of the judiciary, increase the power of the United States government, and really kind of fundamentally remake American society from decisions made by the court. They were more active than ever before in protecting the rights of individuals, more active than ever before in increasing the role of government, and more active than ever before in tackling issues that the legislatures either could not or would not tackle. And we're going to go over kind of three things in general. The first is the case in 1963, Griswold v. Connecticut. The Griswold case in 1963, what was going on here was that a Connecticut law forbade women to use artificial contraception. They said that, every sperm is sacred, pretty much, and that, to prevent a woman from getting that pregnancy was not a disease, and to try to cure pregnancy was, something that the government could regulate and could put a stop to. But in 1963, the Supreme Court ruled against the state of Connecticut and in favor of Griswold, and they said that Connecticut's ban on contraceptives was unconstitutional. That it not only was it wrong, they said, because a judge can't say something is wrong and therefore it's unconstitutional. They have to kind of find a reason why it's unconstitutional. And Chief Justice Warren and his court kind of interpreted the Constitution incredibly broadly and said that the Constitution had in it, in its meaning, although not in its text, a right to privacy, and that state violated this right to privacy when they enacted the ban on contraception. Now, if you read the Constitution front to back, up to down, back to front, side to side, you are not going to find any mention of the word privacy. But the justices needed to find a constitutional basis for their desire to strike down Connecticut's law, so they found the right to privacy in the Constitution. Critics said, they invented the right to privacy in the Constitution, and the critics said that if, Miss Griswold wanted the law changed, she should have worked through the legislature and the governor of the state of Connecticut. But Chief Justice Warren and the court overturned all of those sorts of things and said that there is a constitutional right to privacy, and therefore the state of Connecticut could not, in fact, ban contraceptives. And if the Supreme Court said that the state of Connecticut could not ban contraceptives, the same went for all the other 49 states. So in one fell swoop, the pill became legal all over the United States, and we talked about the effects of the sexual revolution earlier in the block. Critics also charged that it was not the job of the court to make laws, to merely uphold the ones that Congress and the President passed. Their critics began to argue that the courts had too much power over social issues, and these issues should be worked out in the legislature. That's kind of the criticism from the right of the Warren Court and the Berger Court, that they are usurping, if you will, the democratic process. Defenders of the court go on to argue that, rights, cannot be left up to majorities in legislatures, that, a woman's right to, take a contraceptive has nothing to do with whether a majority of legislators agree on that or not. The second case that kind of made Earl Warren stand out as a very progressive jurist was the Miranda case, Miranda v. Arizona. In 1966, the Miranda brothers, two brothers, were convicted of murdering their parents, and the Supreme Court released them on the grounds that they had not been made aware of their rights, that they had given testimony to the police without knowing what their constitutional rights were, and the Warren Court determined that because of that fact, what they said to the police was no longer admissible in court, and without that evidence, the jury could not have convicted them. So they were released and set free. The Miranda Rights are things that we are all familiar with. We've all seen an episode of Law & Order or Cops or anything like that, that suspects had to be informed of their constitutional rights every single time they were arrested. And I'm sure we could all say the formula. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the state. And if you are not read those rights, and if you do not understand those rights, then the cops cannot question you. The cops, anything you say to the cops without understanding those rights is inadmissible in court. This case angered lots of Americans. You know, they looked and said that these two kids who murdered their own parents got off on some kind of silly technicality. And this was not the only technicality. You know, that more and more courts were willing to go further and further down the road of defendants' rights and victims' rights. And many Americans looked at this and said, you know, the whole country is going soft on crime, that, you know, court and jail should be deterrents to crime, and if we're being soft on the criminals, that's just going to make the criminals commit more crimes. And this allowed an opening for politicians, specifically politicians in the Republican Party, to come to power promising to be tough on crime and big law and order guys, that they would really crack down and appoint, you know, judges that, you know, were not so progressive as Earl Warren. Judges that would not defend the rights of criminals, but defend the rights of people who were attacked and criminalized by criminals. That crime, and these accusations were backed up by the fact that through the 60s, 70s, and 80s, that crime in the United States skyrocketed. That the United States was all of a sudden, in many places, not a safe place to live anymore. And a lot of Americans blamed these liberally minded judges and liberally minded justices who were not, you know, kicking ass and taking names when it came to the crooks. And it's the tough on crime policies are a large reason why the Republican Party found so much success in the 1980s. We're going to talk about that more in Block 11. But the fact is that, you know, defendants have much more rights now. Their rights are protected by procedure much more now than they had been before Justice Earl Warren. The last two cases are the Engel case and the Shemp case, and what these two cases did was ended public school prayer in America as a violation of the Establishment Clause of the First Amendment. The First Amendment says, you know, Congress shall make no law respecting the establishment of a religion. And the justices reasoned that to pray constituted an establishment in religion, that even if the prayers were not specifically Christian, that still elevated belief over non-belief, that the government, schools being a government operation, the government cannot advocate that believing in God is better than not believing in God. You know, it used to be, until the 1960s, you know, you would say the Pledge of Allegiance, and then someone, you know, like we do, and instead of saying the Pledge of Ethics, like we do, someone would get on and would pray, and the school would be expected, you know, everyone in school would be expected to stand up and, you know, silently pray along with, you know, the leadership of the school, and that was found to be unconstitutional. Because it supported belief, and the Establishment Clause said that the United States government cannot advocate that believing in God is better than not believing in God. Critics, again, you know, these progressive judges have a lot of critics on the right by conservatives. They argue that the vast majority of Americans don't have a problem with praying in school. Why should you take that away from the 95% of Americans who didn't have a problem with it? And they charged again that the court was taking an issue that should have been dealt with in the legislature into their own hands. Legislating from the bench is the term that conservatives gave to these judicial actions, that they were usurping democracy, that the men in black robes were starting to run the country in a way that the founders never intended them to. But these decisions made by the Warren Court and the Berger Court were very progressive, moved the American courts in a leftward direction in a very big and very important way on so many issues.